Doctrine that limit damage awards. Video 3 of 3. Up to this point, we have addressed damages as an exercise in making the plaintiff whole, restoring as nearly as possible the position the plaintiff would have occupied absent the defendant's wrongdoing. But the make whole principle is bound by doctrine that limit damage awards. We turn to three of the most important limiting doctrines, each of which answers a very different question about how far liability damages should go. The first doctrine is mitigation of damages. The second doctrine is collateral source rule. The third doctrine falls under statutory limitations, two specifically being wrongful death and survival actions. First, let's look at mitigation of damages. Mitigation of damages asks this question. After the injury occurs, that is, after liability has been established, what responsibility does the plaintiff bear to prevent the loss from getting worse? What responsibility does the plaintiff bear to prevent the loss from getting worse? Again, this is after the injury has occurred. Second, let's look at the collateral source rule. The collateral source rule addresses a different concern. The collateral source rule addresses whether or not a defendant should benefit from payments or benefits that the plaintiff receives from independent sources. So you have two parties. You have the plaintiff who's injured. You have the defendant whose behavior is liable for the injury. Now you have independent sources. Let's call them third parties, like insurance companies, who may provide a benefit or a plaintiff or a payment to the plaintiff. The collateral source rule addresses whether or not the defendant is allowed to benefit from that payment to the plaintiff from a third party, which reduces what the plaintiff has to gain from the defendant, right? That's the collateral source rule, and that's what the collateral source rule addresses. Third, let's look at the statutes. Statutory limitations involve legislatures, and it is the role that legislatures play in defining the boundaries of what damage recovery should be in certain circumstances. Okay, so third, we're going to turn to statutory limitations, which are legislative steps that define the boundaries of what recovery of damages should be. Unlike mitigation of damages or the collateral source rule, both judge-made, which is common law doctrine, and statutory made, that's legislatively enacted doctrine, right? They both shape and or restrict damage awards. And again, the two that we are going to discuss are going to be wrongful death statutes and survival actions. So let's start. First category, mitigation of damages. The doctrine of mitigation of damages is often referred to as the avoidable consequence doctrine. That's the avoidable consequence doctrine. Once a defendant's liability has been established, the law does not permit the plaintiff to recover for losses that could have been reasonably avoided after the tort occurred. Okay. The defendant remains responsible for the harm caused by their initial liability, right? And the defendant is responsible for any consequences that may flow naturally from the injury that resulted from their liability. What the doctrine of avoidable consequence prevents is the shifting of additional avoidable losses to the defendant when the plaintiff could have taken reasonable steps to reduce those avoidable damages. Got it? The principle of mitigation of damages, also known as the doctrine of avoidable consequence, right? The principle that this doctrine reflects is an important balance in tort law. On the one hand, tort law aims to make injured parties whole by compensating them for harm caused by the defendant's conduct. On the other hand, the law does not treat the plaintiff as a passive recipient of damages. Once the injury occurs, the plaintiff has a duty to act reasonably to prevent unnecessary escalation of the loss. The doctrine of mitigation of damages, therefore, encourages efficient behavior by both parties. Defendants are responsible for the harm they cause, but plaintiffs must take reasonable steps to prevent avoidable additional injury, right? Avoidable additional injury. This principle is reduced to writing in the restatement second of torts, not in the restatement third, but in the restatement second of torts, section 918. I've reproduced it here for you on slide 9. And it says specifically, except as stated in subsection 2, one injured by the tort of another is not entitled to recover damages for any harm that he could have avoided by the use of reasonable effort or expenditure after the commission of the tort, right? Now, one is not prevented from recovering damages for a particular harm resulting from a tort if the tortfeasor, that's the defendant, intended the harm or was aware of it and was recklessly disregardful of it, unless the injured person with knowledge of the danger of the harm intentionally or heedlessly failed to protect their own interest. So when it comes to the restatement second of torts, section 918, mitigation of damages, also referred to as avoidable consequences, our primary focus is going to be on subsection 1. That pause was intentional for you to have an opportunity to actually look at subsection 1 again, if that was helpful. All right, so let's move on. Because mitigation operates as a limitation on damages, remember, mitigation is a limitation on damages, the burden of proof then rests on the defendant. Pay attention. Because mitigation operates as a limitation on damages, the burden of proof rests on the defendant. The defendant must demonstrate that reasonable mitigation measures were available to the plaintiff. 2, the defendant must establish that the plaintiff failed or refuse to undertake those reasonable measures, and the defendant must establish that the failure of the plaintiff to undertake those reasonable measures resulted in additional avoidable harm. So there's three things that the defendant must prove. This is a conjunctive rule, so all three of these pieces must be present. One, that there were reasonable mitigation measures available. Two, that the plaintiff refused or failed to undertake those reasonable measures. And three, the failure of the plaintiff to undertake those reasonable measures resulted in additional avoidable harm. This is for mitigation of damages. If the defendant cannot establish all three, then the plaintiff's recovery will not be reduced. Okay? Understand, plaintiffs are not required to undertake extraordinary measures or accept unreasonable hardship. For example, a plaintiff may be expected to obtain a routine medical treatment or seek reasonable substitute employment if capable of working once an injury has occurred. However, the law does not require plaintiffs to undergo experimental surgery, dangerous surgery. The law does not require plaintiffs to incur unreasonable expenses or radically alter their lives in order to reduce the defendant's liability, right? So we're not looking at extraordinary measures. We are looking at reasonable measures that are available that the plaintiff does not undertake, the failure of which, right, the failure of not undertaking those reasonable measures result in additional harm that could have been avoided. Got it? Mitigation usually arises in three circumstances. Mitigation usually arises in three circumstances. One, a medical context, right, where the plaintiff must accept reasonable medical treatment, but our plaintiff is not required to undergo high risk or experimental treatment or treatment that may cause substantial pain or indignity. The second frequent context is the employment context, right? A plaintiff must make reasonable effort to obtain comparable employment, but they are not required to accept inferior positions, relocation, or work that is demeaning. And the third context is property damage. Plaintiffs are expected to exercise reasonable steps, right? Reasonable steps to prevent further property damage. Example, covering a damaged roof after a storm. Failure to act does not result in no recovery, but it does result in no recovery for the additional avoidable deterioration. Get it? Make sense? All right. Remember this, it's really important. The doctrine of mitigation of damages or avoidable consequences does not reduce recovery for the original injury itself. It just operates to limit recovery for additional harm after the initial injury that could have been prevented. Makes sense, right? In all three cases, the doctrine operates as a practical limitation on recovery while preserving the central principle of tort law. Defendants remain responsible for the injuries they wrongfully created as a result of their liable conduct or behavior, right? Defendants remain responsible for those injuries, but any injuries after the fact that could have been reduced or avoided become the responsibility of the plaintiff. Now, let's move on to the collateral source rule. Ready? The collateral source rule. Excellent. There we go. Here's a question. Can the defendant reduce liability? Can the defendant reduce their liability when the plaintiff receives compensation from some source other than the defendant? I'll say it again. Can the defendant reduce their liability when the plaintiff receives compensation from some source other than the defendant? The collateral source rule says no. Under the collateral source rule, payments or benefits received by the plaintiff from some source other than the defendant does not reduce the damages recoverable from the defendant. For instance, if the plaintiff's medical expenses are paid by, let's say, health insurance or disability insurance or some source other than the defendant does not get a discount on the amount of damages that they are responsible for. The defendant remains responsible for the full amount of the damages caused by the defendant's negligence. Get it? The defendant doesn't get a discount because some source other than the defendant has paid some part or even all of a damage recovery, right? This doctrine rests on several principles. Well, let's look at it. First, courts reason that a wrongdoer should not benefit from the foresight or contractual arrangements of an injured party. If a plaintiff has prudently purchased insurance, allowing the defendant to reduce damages by the amount of the insurance payments would effectively transfer the benefit that belongs to the plaintiff to the defendant, right? Get it? If the defendant owes you $5 because of some negligence liability, and you had insurance that pays you $2, what's left is $3, right? Well, if the defendant gets the benefit of that reduced $2, now the defendant only owes you $3. The defendant received a discount. Well, the defendant is the liable party. So, right, when you think about it, it makes sense that the defendant shouldn't benefit from a payment that's made by some source other than the defendant. Number two, courts do acknowledge that this rule may sometimes produce what we like to call a windfall. Do you hear my question? We like to call it a windfall. And what I'm saying by this questionable windfall is a plaintiff may receive compensation from both the defendant and the collateral source, right? Both the defendant and the collateral source. So that sounds like double recovery, right? Put a pin right there. I've got a rule that addresses the double recovery. So don't fret. The third policy that the collateral source rule relies upon is encouraging socially beneficial behavior. Encouraging socially beneficial behavior. How is it encouraging socially beneficial behavior? By preserving the value of insurance coverage, right? If insurance payments automatically reduce tort recovery, it's believed that individuals would have less incentive to purchase insurance or even participate in employee benefits plan. So the collateral source rule helps maintain this socially beneficial behavior. Okay. I want to skip a couple of places because I want to get to this rule before we get too far away from it. Now, I'm going to go back. Sorry to give you whiplash. Let's go back. Remember the second policy, understanding that the plaintiff may get double recovery? Well, I want to take you to this rule that's called the one satisfaction rule. And under the one satisfaction rule, right, the plaintiff is prohibited from double recovery. So the plaintiff is prohibited from double recovery. Under the one satisfaction rule, a plaintiff is entitled to only one full recovery for a single harm. A plaintiff may not obtain duplicative damages for the same injury. So if there was a situation, let's go back, where you have a defendant who owes the plaintiff $5 and the plaintiff had insurance that covered $2, well, we know under the collateral source rule, the defendant is going to have to pay the full $5 judgment. And now we have the plaintiff with this extra $2, right? Wrong. Under the collateral source rule, that $2 would have to be returned to the insurance company. So there is no double recovery. There is no double recovery. Okay, let's finish out the collateral source rule. The collateral source rule does two different things at once. Number one, the collateral source rule serves as a substantive rule, right? It's a substantive rule. What do I mean by that? The defendant cannot reduce liability. Substantive, right? Substantive rules address rights and duties. So it's a substantive rule because it prevents the defendant from reducing their liability. Okay. The second role that it plays is it's an evidentiary rule. What do I mean by that? I mean that pursuant the rule of evidence, the collateral source rule prevents the jury from receiving information about the plaintiff having received payment from some other source, right? So it's also a rule of evidence. Yeah. The collateral source rule is also reduced to writing in the restatement second of torts. It's not in the restatement third yet. The restatement second of torts, section 920, which is the benefit to the plaintiff resulting from the defendant's tort. So we do have a restatement rule for the collateral source rule, and that is the restatement second of torts, section 920. Okay. All right. We've already talked about the one satisfaction rule. So plaintiff does not benefit from double recovery. And that's the collateral source rule. Let's move to our third category of limitations, and those are our statutory limitations. When a tort results in death, the law of damages must address at least two questions. Question number one, whether the victim's claim, that's the person who died, whether the victim's claim survives the death, and whether the surviving family members may recover from their own losses. So we're looking at two things. We're looking at the plaintiffs, or well, if they were alive, they would be the plaintiff. We are looking at the plaintiff's claim once they've died, what happens to it. And we are looking at what claims the family members may have as a result of injuries or harm that they suffer due to the death of the plaintiff. Okay. Wrongful death is the first one we're going to address. A wrongful death statute creates an entirely new cause of action on behalf of the decedent's surviving family members. Plaintiff is injured, plaintiff dies, family members survive, right? Plaintiff suffers from injuries, plaintiff dies, family members survive. A wrongful death claim does not belong to the decedent. A wrongful death claim belongs to those who suffer losses as a result of the loss of the decedent. Yeah? So if this is for a family member that has survived, you can start to think, well, what losses might be covered? Well, the plaintiff has died, the family member survived, and the family member can seek damages. What kind of damages do you think those would be? Loss of financial support? Okay. Loss of companionship? Yeah. Loss of parental guidance if it's a child? Okay. Funeral expenses, just to name a few, right? Just to name a few. Well, if the wrongful death is for the benefit of the surviving family, then what's a survival claim? It's just the opposite, right? That makes sense. The survival claim preserves the decedent's own cause of action, right? So in other words, the survival claim survives the decedent's death and becomes a part of the decedent's estate, right? So the estate may recover damages that the decedent could have recovered had the decedent lived. And that's going to include medical expenses before death, lost wages before death, pain and suffering up to the time of death. Does that make sense? We're going to take each one of these in a little bit more detail, but that's the general overview of a wrongful death claim versus a survival claim. Wrongful death claim is for the family members that are left behind by the death of the plaintiff. And the survival claim is for the decedent, or the plaintiff who died. Okay. All right. Let's go back to wrongful death. And let's take a couple of steps in this world to get some understanding of what wrongful death claims cover. The core purpose of a wrongful death claim is to compensate the surviving family members. And they're not being compensated for the death of the person. They're being compensated for the losses that they suffer because of the death, right? What did the family member lose when the person died? What did the family member lose when the person died? Well, let's look at some examples. Number one, a wrongful death statute. Remember, these are statutes. So it's possible that we have 50 different wrongful death statutes because we have 50 different states. So remember, this is a statute. This isn't a restatement. This is a statute. The wrongful death statutes will cover who has standing to bring the lawsuit. Usually it's going to be the spouse of the person who died, the children of the person who died, and dependent upon the facts, maybe the parent of the person who died. Okay. What can be recovered? Loss of financial support, loss of services, sometimes loss of companionship, right? Wrongful death does not compensate for the death, but it compensates the survivors for loss. Get it? Wrongful death does not compensate for death, but it compensates the survivors for the loss. Now, we're going to look at survival actions. Survival actions, also statutes. Survival actions limit the recovery to pre-death harm. Why? Because survival actions focus on the harm that the decedent suffered up to death. This isn't for the family. This is what the decedent would be able to seek recovery for if they were still alive up to the point of death. All right. So what did those damages include? Medical expenses, lost wages, pain and suffering. But again, all of this is before death. What is the purpose? The purpose is to preserve the decedent's cause of action, right? If the decedent had lived, the decedent would have been able to bring this relief request on their own. So what we're asking is, what could the person who's now dead, had they recovered, what could they have sued for? And that goes up to the time of death. Make sense? Okay. Focuses on injuries, focuses on suffering, and it focuses on the losses before death. When a person dies, their legal claims doesn't disappear. That makes these survival actions make a lot of sense, right? Instead, those claims become part of the decedent's estate. So we've read a number of cases where someone in a tort action is acting on behalf of the deceased, right? The decedent is no longer alive to bring the lawsuit themselves, so the law authorizes a substitute party. Again, these are statutorily driven, which means you have to look at the statute to see who qualifies to serve as that substitute representative. Any questions? That's all we are going to address when it comes to the limitations that are placed on damages. That was one, mitigation of damages, also known as the doctrine of avoidable consequences. Two, survival actions. And three, I'm sorry, two is the collateral source rule. Three are statutory limitations, one being wrongful death, and the second being survival actions. That's the end of this video, which makes that the end of damages. Fantastic. If you want to practice your understanding, there's a few slides after this that has some questions, right, that you can go through. Multiple choice. It gives you the correct answer ultimately with a brief explanation. So again, if you want to spread your wings a little bit and test your understanding of this doctrine, there's some questions at the end of the PowerPoint. Have a great one. Thank you.